we are actually very much thankful to Swarajji for agreeing to come in his hectic schedule. He is engaged with many travels and lot of seminars and programs, not only in India, even abroad. And the last week also he was heavily engaged with many programs, and he had to go to Bombay and somewhere else and come to Kerala. And maybe from here also he is moving ahead to some programs. And Swarajji was sharing that from Tamil Nadu, some of our groups, they have also organizing a program on this topic on the next week. Somebody has invited him, but because of his heavy schedule, he couldn't go for Tamil Nadu program, he cannot. But anyway, he has promised, because when Kerala, the Dalit organizations, Ambedkarite organizations, community organizations have come together, and we had some deliberations, discussions, and we came into a common view or perspective that this August 1 Supreme Court judgment on this classification will destroy the unity of the people, destroy the unity of Dalit community. Also, it is threatening, or maybe it's endangering the ongoing developing Ambedkarite movement, as well as the larger unity of scheduled caste and scheduled tribe people across the nation. So that's why we took this initiative to have the South Indian Conclave during last October 13th and 14th. And in that event, we invited Ashok Bharati from Delhi as the national president, chairman of NACDOR, a network organization, and from also Prabhakar Rajendran from Karnataka. He was representing the NADO, National Alliance of Dalit Organizations. Some 15 large organizations are there. Then such important dignitaries came to participate in our deliberations. And in this National South Indian Conclave, PCK also from South India, PCK, Vidudalai Chiril Kakshi from Tamil Nadu has taken an active participation. And we know that they have two MPs, Thol Tirumalavan and Ravikumar, two MPs. And they are also strongly taken a stand regarding this new judgment, and they have also participated in our today South Indian Conclave. And as a continuation of South Indian Conclave, Ashok Bharati has announced from Kerala that he is taking the leadership of organizing the National Conclave during February 1st week. So this workshop is a preparatory workshop to strengthen our views and also to build a collective perspective on the issue of preservation, especially the classification, how this classification or this judgment threaten the future of the Dalit movement as well as the community, and how it is contradicting the basic fundamental values and principles of Constitution, especially the basic concept of social justice and affirmative action principle. So, about SK Swarajji, we are grateful and we are lucky that now we have with actually SK Swarajji is with us, and maybe he is considered as the most authoritarian and maybe the most accepted intellectual available for dealing the subject, as well as talk about Baba Ambedkar, the ideology of Ambedkarism, as well as Dalit issues. And he is his specific area as he was the former chairman of UGC, and during his tenure he brought lot of reforms in these academic practices prevail in these practices at the universities, and he had this vision of affirmative action. And SK Swarajji is known as a authority on the subject of affirmative action. He has conducted thorough study and research on this area, and his books also has been published under the affirmative action and this reservation in private sector. Many publications have come, and on the development issue also he has brought many studies, and hundreds of publications appeared in different journals, internationally accredited journals, and also many texts from not only from India, even some Western publishers got many of his books published on the topic of development, then affirmative action, and different policy level issues. So he is a policy expert also, and his status is he is an emeritus professor. Such a great status he is enjoying, and I know that his son Amit Thorat is also an academician, now working in JNU as an academician, a professor. Thorat is also contributing towards strengthening the Ambedkarite and Dalit ideology and perspective. So on this issue, after the Supreme Court judgment pronounced on August 1st, maybe S.K. Thoratji has come forward his elaborative article in Outlook. He has published an article, and it's very detailed account the different aspects of this judgment and how the classification is actually contradicts the constitution, as well as how it is its irrationality of this judgment is very much is explained with proper data, figures and everything. So I also had opportunity to meet him many times during different academic sessions. Maybe last year we were together in the South Indian National Conclave in Hyderabad. So in lot of such occasions I got the blessing of meeting him, and his wife also, I am referring, Vimat Thorat. She is also an academician working maybe in Hindi. She is a Hindi professor, and she has been very actively participating or taking a role in preparing the black paper during 2001. Before the Durban conference of 2001, international UN conference against racial discrimination, all over India, our Ambedkarites, theoreticians and academicians came together to bring out a black paper giving detailed account of our socio-economic status. And his wife, Vimat Thorat, has been an active member of that NCDHR campaign. So that campaign I also worked as a national committee member along Vimat Thoratji. So today, and he is dealing this specific topic on subclassification and the constitutional aspects. And I have handed over our proposed draft regarding this classification issue, and yesterday we have presented it here. And sir, we are looking, when we oppose the classification, when we say we reject classification, what can be a legal or constitutional mechanism so as to include this most marginalized section of the community. So we would like to have an inclusive approach, whereas these people also have to be taken into consideration, and for the larger interest of Dalit unity, we must have some packages, some special packages. So that is what in our draft bill we propose, and we valued your comments and your opinions regarding this proposal. And also there are some issues. Now some academicians or some writers are raising the issue of constitutional contradiction. Their argument is that even they are quoting the Supreme Court judges, they are confusing the people now. The provisions on reservation, provisions of the reservations are contradicting the principle of equality. Article 14, 15, provisions of equality is in contradiction with the provisions for reservation. So they are raising the new issues of such contradictions are there. Then on this the authority of the how far the Supreme Court have the right to intervene the issue. Do they have the capacity to formulate policies? Can they recommend or can they ask the government to do that? So what is the constitutional validity of this judgment, all these things? So these are the areas, and we hope your presentation will give us a proper understanding and also a proper light towards how we are moving forward and regarding what can be done as a solution part thing. So in this actually there is a special request in this presentation. Please, all of you, please silent your phone, put in silent mode, and also you can all after this presentation we will have 1 hour deliberation. Discussions are there, so we can write your questions and we can have a healthy discussion after the presentation. So at this juncture, in actually on behalf of the research committee of the National Conclave of SCST organization, all our brothers and intellectuals actually attending here, I warmly welcome Professor S.K. Thoradji to this session. Welcome, sir. Thank you very much.
Good morning to all of you. Good afternoon, other distinguished guests on the dais, and the participants. Am I sufficiently audible? A little more. Good morning to all of you. I am very happy that I have been able to adjust my visit to Kottayam with a lecture on the Supreme Court decision on the issue of subclassification. I am also equally happy that various organizations in Kerala, they have come together and sort of form a platform or a forum to discuss the decision of the Supreme Court on subclassification and take a view. And also, I understand you have gone a step ahead and you are recommending some act or a bill on the part of the Kerala government to address the problem of most marginalized among the scheduled caste. The judgment of the Supreme Court on subclassification and reservation for the most backward among the scheduled caste has become a subject of intense debate and discussion. Am I audible to all of you? So this issue has become a subject of intense debates and argument for and against. You might have seen the number of articles that have appeared in Indian Express.
This is correct. Well, that's maximum, I think. A little bit you can access.
Okay. Is it fine now? It's okay?
The part.
Okay. So A number of newspapers carries the article. The Indian Express particularly published several articles. The Outlook carried a special issue on caste versus caste. Beside the discussion of this issue for and again, there has been a sort of protest, particularly among the North India, from Bihar, UP, Delhi, by the people and the lawyer. Now, you have taken up this issue. I understand you are a sort of federation or organization of organization, and that there are individual people also in that. Have taken the issue of this sub-classification. I was pursued by Ambu Actions. If your name is somewhat Amburajan, I know, but it's not Amburajan. Ambu Action has really pursued me for last 10 days or so to come and sort of meet you and sort of discuss this issue. I am the chair of K.R. Narayanan chair in Mahatma Gandhi University, Kottayam, and also a chair, Ambedkar chair in Kochi. So I am associated with Kerala, and it is my obligation to propagate the Dr. Ambedkar's ideology in Kerala, because Kerala government, Kerala universities have taken initiative. The specific issue that has been told to me is to share my views on the Supreme Court decision. What I will do is this okay? This is better? Somebody told me?
Yeah, that will be more better.
Yeah. So stop it. Okay? Okay, great. But if I got to hold it for 1 hour.
That's better.
Okay. So let us look at the Supreme Court decision. What I will do is the following. I will discuss the Supreme Court judgment and point out the limitation of this judgment in my view. That will be the first part. As has been suggested, that it is also necessary that we address the problem of most backward among the scheduled castes. So what policies or what approach we can take. I will also share with you my view on that. And also there are several other views, several other points which I would like to share. Let us understand first that what were the agenda, what were the issues before the Supreme Court. Just give me a minute. Now the major issue before the Supreme Court was the following. The Constitution bench had to educate upon whether the subclassification of the scheduled caste for the purposes of providing affirmative action including reservation is valid, which was given in Punjab and Haryana. In this context, the following issues were for the consideration of the bench. Number one, whether subclassification of the reserved class is permissible under Article 14, 15 and 16 of the Constitution. Whether scheduled castes constitute a homogeneous or a heterogeneous grouping. Whether Article 341 creates a homogeneous class through the operation of the dimming friction, and the last issue was whether there is any limitation on the scope of the subclassification. Let me sort of, in a simple way, present before you what does it mean. The issue before the Supreme Court as presented by the Punjab High Court was that can we classify the scheduled caste further, subclassify, and give a reservation to the most backward among the scheduled caste. The criteria to identify the most backward is another issue which I will take. This was the first issue. Now to enable the Supreme Court to say that it can be subclassified, the Supreme Court has to decide on one more point, and that too, whether it is a heterogeneous or homogeneous. The heterogeneity or homogeneity is necessary, they thought, that if it is heterogeneous on the basis of some indicator, then you can subclassify. But if it is homogeneous, then you cannot subclassify. So the Supreme Court had to decide whether a scheduled caste which is created under 341 is a homogeneous or heterogeneous. That is the second issue. The third and last issue was that if there is a reservation based on the subcaste to the most backward subcaste, which means if there is a reservation based on subcaste within the scheduled caste, then which caste you should consider, how long you should go, because there are hundreds of subcastes within the scheduled caste. For example, the Bihar, which has conducted the caste census, identified about 22 subcastes within the scheduled caste. So where do you apply reservation? Do you apply for 24 or you apply for 2, 3, 4 major? That was also the issue on which the Supreme Court was required to give a decision. So these are the three issues. Now I will share what is the judgment in my understanding. But what the bench has done is that this was the agenda, this was the mandate given to the Supreme Court bench. But the bench went ahead. They also made suggestion and recommendation which were not the part of their agenda or what were they were asked to give a decision. If you look at the recommendation, other than the Supreme Court judge, other than the Chief Justice, the other 5 judges have recommended 4 or 5 things. And those are very serious and important issues which you should understand, because they might be applicable at any time. One is that the creamy layer among the SC/ST should be introduced, and a creamy layer should be excluded from the provision of reservation. That is the first issue. The creamy layer that is applied for the OBC. Secondly, that reservation should be applicable only once or only one generation or one generation. Third, that there should be a time limit for the reservation beyond which the reservation should not continue. Fifth, that economic criteria should be applied for reservation and it should be replaced by the criteria of untouchability or caste. Reservation should also be discontinued because it promotes inefficiency. So therefore, this is also suggested that the alternative or new policy in place of caste-based reservation may be introduced The reason is that it introduced caste system. It introduced caste feeling. These are very, very important recommendation made by the other judges. Now you can see that this judgment is very, very important because it attacked the reservation system on all front. There is no aspect which is not left out. That is, it is not only recommend sub-classification, but they also suggest a creamy layer. They also suggest that there should be a limit on the reservation of one generation or use of reservation only once. Therefore, there should be a time limit. Economic criteria should be introduced. Reservation based on caste should be replaced because it promotes inefficiency and also it promotes caste feeling, and therefore the alternative criteria which is not based on the caste should be used. Now you can see that there is nothing left out. All criticism, reservation is being attacked or denied or criticized on several grounds. This is the first thing that you must understand, that what is the canvas of this judgment. And therefore you will recall that the Chirag Paswan along with certain MP went to the Prime Minister and expressed the dissatisfaction about the creamy layer, and the government declared immediately. So creamy layer recommendation was not imaginary, it was real, and therefore government said that no, we won't accept creamy layer for scheduled caste, scheduled tribe. But there are other limitations. And one of the judges who argued against the Supreme Court, against the decision of sub-classification, Dr. Chauhan, he said that although at the moment this may not be taken into account, but they are on the record now in one of the judgments. So next judgment, the other judgments which will come about the creamy layer, about efficiency, about one generation, they will, this decision will provide justification. It was not necessary for the judges to give their opinion about the creamy layer, the time limit, one generation or once, economic criteria, efficiency, because this was not their agenda. This was not the issue placed before the bench, but they did give, and that shows the attitude of the judges which were the member of this. So this is the first part, that you know now what this judgment is. Now let us come to the judgment of sub-classification. And this is written by only Chief Justice of India, Chandrachud, and it is supported by other in their separate judgment, separate note. Now what are the main point of the Chief Justice? The main point of the Chief Justice is that the Chief Justice supported the sub-classification. The Chief Justice supported sub-classification on the ground that the scheduled caste, the way it is defined in Article 341, is a heterogeneous group. It is not a homogeneous group. And since it is a heterogeneous group, the most backward subcaste among the scheduled caste can be given reservation. This is the major recommendation of the judgment of the Chief Justice of India, which was supported by all other judges except one. Now, Chief Justice also gave his opinion that to what extent the subcaste should be taken for the purposes of reservation. I will share with you. Now, what is the method that Chief Justice followed? The Chief Justice followed the following method to arrive at this particular decision in support of subclassification. That method is the following. Please understand, that's very important. the method that follow is that the Chief Justice has taken a review several decisions, several judgments. Chief Justice has reviewed several judgments on this issue in the past. That whether subcaste reservation can be given, whether the scheduled caste is a heterogeneous or homogeneous community. Several judgments, I think there are about 7 to 8 judgments are there. Now the Chief Justice reviewed those, and those decisions are not, they are divided into two. Some judgments say that scheduled caste is a homogeneous category created under Article 341. How they are homogeneous? Because all scheduled castes are defined on the basis of untouchability. All the scheduled caste and subcastes suffered from untouchability, and untouchability is defined. I will come to the definition of untouchability later on. That untouchable being an impure and polluting caste, they are denied several rights: social, religious, cultural, civic and economic and educational rights. So those criteria are taken to define untouchability, and there are other criteria. So since there is a homogeneous criteria by which the castes are defined as a scheduled caste, it's a homogeneous category and it cannot be further classified. And therefore, if it cannot be further classified, reservation cannot be given on the basis of subcaste. This is the one viewpoint taken by few judgment. There is another group of the judgment which say that no, scheduled caste is a category which is heterogeneous category. Several subcastes or several scheduled subcastes are grouped into together for the purposes of reservation, and that doesn't mean that they are homogeneous. They are heterogeneous, so they can be further subclassified and reservation can be given to subcaste. Now these are the legal judgment, understand that. Now a person like me who is an academician, I am sort of amused how on one issue there can be two viewpoints or there can be several viewpoints. But we have no choice. That is how the Supreme Court judgments are given. Now, after reviewing these two contradictory views, Chief Justice of India supported legally that scheduled caste is a heterogeneous group. It can be subclassified, reservation can be given to the most backward class. One of the points that you should understand that in the beginning itself, Chief Justice say that the Constitution talk about substantive equality. That Constitution should achieve substantive equality. What is substantive equality? Substantive equality is that there should not be inequality between the different subcastes in terms of representation in the government services or even in terms of social and educational development. And then he also argued that if there is a disparity and inequality within the subcaste among the scheduled castes, then there is no substantive equality. So to be able to achieve the substantial equality, that is thereby the meaning of substantive equality is that all the subcastes are on fairly similar development, and if that is not there, then you have to have a policy which will favor those who are most backward among the scheduled castes. So on this ground, he suggested he favor those all Supreme Court decision which favor heterogeneity, subclassification and reservation for the subclass. Now, I am not a jurist, I am not a person of legal standing, therefore I cannot really give my opinion. There are lawyers here and there are lawyers here. But I was promoted, I was induced to write an article in Outlook critical of the decision of the Supreme Court Judge, Chief Justice of India, for one reason. That the Chief Justice of India has not only taken a, not only justifies heterogeneous and subclassification and reservation for subcaste on the basis of legal ground, but also on academic ground. Had he confined himself to the legal ground only, we would not have said anything. I would not have said anything. But he went beyond that. And he used 4 or 5 study by the researcher like me to prove the point that scheduled caste is a heterogeneous community, that there is a untouchability and discrimination within the subcaste among the scheduled caste, and therefore scheduled caste is heterogeneous and there is a justification for subclassification and reservation. Now my point is that, to cut the short, that the justification given by the Chief Justice of India has its own limitation. Academic justification, I am not talking of legal now, legal is old. But academic justification, the evidence from the research studies on the heterogeneity of the scheduled caste, subcaste within the scheduled caste, in my view is based on a very weak foundation. And therefore, his conclusion is also very weak and subject to limitation. How? The Chief Justice of India had taken 4 studies, 2 from Gujarat, 1 from Andhra Pradesh and 1 from Tamil Nadu. The Gujarat study, 2 Gujarat study, one by Shah and another by Martin McQuarrie. These studies have studied the social differentiation, untouchability within the subcaste of scheduled caste, and came with a finding that some subcaste which consider themselves to be higher in social status than the other subcaste practice untouchability. Then Andhra Pradesh studies also, Usha Rani or something, and Tamil Nadu study also made a similar point. Now, since some subcaste, maybe in Kerala Pariyar, practice untouchability against the others subcaste above the scheduled caste, or maybe in Maharashtra, Mahar practice untouchability against the Matang and Chamar, or in northern India, Chamar practice untouchability against Valmiki, or the high subcaste practice untouchability against Arundhatiya in Tamil Nadu. I am giving the example. But he draw the evidence for the 4 studies. Now, what is the nature of these studies? What is the nature of untouchability? The nature of untouchability within the scheduled caste, which comes out in this study, is in the social sphere, sociological sphere. That is, that the subcaste do not intercaste marry within the caste, that they don't have possibly sometime the intercaste dinner, they perhaps have a separate temple and they don't allow one subcaste to pray the god of their temple. So religious and social discrimination is pointed out there. And it is on the basis of that, Chief Justice said that there is an untouchability within the scheduled caste and that they are heterogeneous, and therefore those who face from untouchability by other subcaste among the scheduled caste are perhaps most backward and they should be given reservation. Now, what are the limitations of Chandrachud decision? The limitation of the Chandrachud decision are following. That before I go to the Chandrachud limitation of his decision, let me talk what is Ambedkar's view on this. Dr. Babasaheb Ambedkar's view on this. Now, it was Dr. Babasaheb Ambedkar in 1919 and 1930 argued that all subcaste which face untouchability because they are considered polluting and impure and therefore they suffer from several disabilities, denial of rights, civic, religious, cultural, but also economic and educational. They are called they are called untouchable, and they should be given reservation, or they should be given legal protection against the discrimination. First demand was there should be law against discrimination. Second was that since they are discriminated, they should be given appropriate share, and for that giving appropriate share, a reservation policy was recommended, both in legislature, in public sector job and education institution. Now Dr. Ambedkar was also a member of the committee set up in 1930 by the Bombay Presidency. It is called a Backward Caste and Aboriginal Type Committee. And in that committee also has a chapter that is untouchability within untouchable. And it came with a similar finding, that is a finding similar to that of Gujarat, Martin Makwan or Shah, that yes, there is some sort of untouchability, but it is in the cultural sphere, religious sphere, social sphere. They did not refer to the education and economic sphere or employment sphere. So you can see that Chandrachud only found untouchability within the scheduled caste in social, cultural and religious sphere. It is silent. It does not give any evidence on discrimination of the scheduled caste in employment, scheduled caste in businesses, scheduled caste in economic sphere, and scheduled caste in discrimination in education. So you will see that there is no reference to the discrimination practiced by the subcaste within the scheduled caste against other subcaste in employment, in economic sphere, that is sale and purchase of land or business, sale and purchase of the commodities, or in education sphere. That the Pariyar here, for example, do not stop the other subcaste from going to the school or education. They do not discriminate in employment. They do not discriminate in business. So, Dr. Ambedkar referred to both socio-religious or social discrimination and economic discrimination. But Dr. Ambedkar did not propose reservation within the subcaste. He recognized that there is untouchability between the subcaste in Bombay Presidency, in social sphere, but he did not recommend a reservation for the subcaste. He said that all subcastes suffer from untouchability, denial of equal right in social, cultural, economic and educational sphere by the high caste. The high caste discriminated equally, more or less equally, all the subcaste. There may be some difference. For example, in Kerala, when the high caste discrimination against Pariyar and others, the discrimination degree doesn't vary much. It varies a little. The discrimination, say, attitude of humiliation and condemnation, humiliation is much more in case of Valmiki sweeper, because they are engaged into so-called dirty job, as against those who are engaged in leather. So there is some difference, but basically in terms of denial of right, the high caste discriminate against all the scheduled castes more or less equally. Therefore, Dr. Ambedkar argued for a reservation for all the subcastes based on untouchability. He did not recommend the reservation for the subcaste. This is Dr. Ambedkar's argument. Let me go to the Chief Justice argument and then I come to the end on this point. Now, the Chief Justice say that subcaste, within the subcaste there is untouchability, so there is a heterogeneity, so the most backward among the subcaste should be given reservation. Now, let us understand one thing, and this is for your argument also, that the reservation when the reservation is mentioned, Article 15, it is a reservation representation in the public sector job. It is not talking reservation in private sector, or it is not talking reservation in businesses or in agriculture or public housing. When they are discussing, they are saying that some subcaste are underrepresented in government jobs. Now, and then Article 16 say that nobody will stop the government from developing a policy for the social and educational development of the scheduled caste, in order to ensure the adequate representation in the public job. So, the Constitution gives both the objective and the source also. The Constitution says that in order to achieve adequate representation in the public sector job, government should take policies of economic development, social development and educational development to assure adequate representation. Now, let us get clarity on one particular point, and that is, on what factor does the representation in government service depend? The employment in public sector job, government job, is a function of education. If you are a graduate, if you are a postgraduate, your employability is high, you are likely to get a job. And you can get education provided you are economically well off. Your father is economically well off. And if your father is not economically well off, but here is a government which provide all funding to the student, free education, scholarship, hostels, still the education development can take place. So, the individual within the subcaste, whether he will get an employment in the government, will depend on the educational level, which ultimately depend upon the economic standing of the father and the government policy. And Dr. Ambedkar, therefore, in 1930, when there was agitation for entry of the Mahad tank and the entry into the Nashik temple, and the high caste did not allow, he openly says that don't fight for this entry now. Fight for reservation, fight for employment, fight for education development, fight for economic development. This is the reason. Now the issue is, and understand the limitation of this Chief Justice argument and how he has stretched the argument artificially. Now, if the employment in the public sector is a function of education level and education is a function of your economic standing and government policy, is there a heterogeneity? Has the Chief Justice found in this study heterogeneity in employment, heterogeneity in educational development, heterogeneity in ownership of land between the subcaste? There may be inequality between the subcaste in the educational level, which is the educational level, ownership of land, ownership of business, and also employment. There may be more of them may be employed in a casual labor. There may be inequality within the subcaste, which is the cause of lower representation. But has Chief Justice got that data from these studies? No. Because there is no data in these 4 studies that he has referred to on the discrimination by the subcaste, higher subcaste among the scheduled caste, a higher subcaste of the lower subcaste among the scheduled caste, on discrimination in employment, education and business and land, which is very important for representation. Now you can see that had there been a evidence provided by the Chief Justice that some of the subcaste among the scheduled caste are lacking behind in employment, lacking behind in ownership of land, therefore lacking behind in education vis-a-vis the other, and those who lag behind employment, ownership of capital assets and income and education, and as a result their representation low, they should be given a reservation. I could have understand it. whether we support it or not, but at least he would have given an argument. He has not given an argument. What is the argument has given? He has referred to the discrimination or untouchability within the scheduled caste to social sphere, intercaste marriages, intersocial relation, restriction on the god and the entry into the temple of some subcaste. I don't know whether it is in Kerala or not. So he has given the social untouchability within the social sphere as a justification of heterogeneity. He has not given heterogeneity in economic sphere, lower employment among some subclasses, lower ownership of land and business, lower education level as justification for heterogeneity and for reservation in representation. So you can see the major limitation of the Chief Justice argument. He has fetched his artificial, because his intention was somehow declare that they are heterogeneous and somehow justify the reservation. So that is the first. I am taking more time simply because it is very difficult to understand how the logic has been developed to justify the reservation. So let me summarize now. The major problem with the subclassification argument is that the reason which result into underrepresentation in government services of some subcaste among the scheduled caste is low education, low ownership of capital asset and low income and low employment, regular salary. So you will find, I have done an exercise before I come to Kerala. I have taken those scheduled castes individual who are represented in government service and those who are not scheduled caste, and see the reason why some scheduled castes are not in government job in the same degree as the other scheduled caste, subcaste. The 4-5 reason comes out, 3-4 reason. One is that the family size of some scheduled caste, subcaste is more. Second, that father education is better. If your father education is better, then the father will send his son for education or his daughter for education. Father education is important. Then the income of the father. If he owns a land, if he is in business, his income is high, he sent his son and daughter for education who became capable to get a government job. So you can see that the income of the father, the education level of the father decide the education of the children and his capability or her capability to get a government job. This is the crux. Now Chandrachud has not, Chief Justice has not studied this. He did not have a data. He took the social indicators which have no relationship. Your representation in the government job will not be low because one subcaste is observing social differentiations against other. The public sector representation of one subcaste will not be low because the other subcaste is not marrying. Those are the issue of dignity. Civil rights are denied. They cannot be justified. But for representation purposes, the determinants are different. And he doesn't have a data at all. So he took a wrong statistic, not a right statistic, because that statistic was not available, and still gave a judgment. That is the limitation of the judgment of the Chief Justice of India, and therefore he has stretched it out, a lot of stretching it out, because the purpose, it was decided that we have to give a decision. Because some big leader has already declared that yes, subclassification is important, reservation is important. That is the first point. Sorry, I have taken some time on this. Now, let us come to the solution itself before I go to the key layer. I think Ambushekhar has asked this question, and you have also the bill or draft bill also. Dr. Ambedkar, who accepted that there is an untouchability within the scheduled caste, did not recommend reservation based on subcaste, but he dealt with the issue. He did not ignore this issue. I'm just sharing with you so that you know what Dr. Ambedkar did, and then it will help you to frame your bill. What Dr. Ambedkar did was he was aware about the casteism within the subcaste, and he was aware about the discrimination of all subcaste in the form of untouchability, which means denial of civic, religious, cultural, employment, educational and economic right. Therefore, he brought all them into one category, homogeneous category. Dr. Ambedkar was the only one. For the first time, he brought this homogeneity among the untouchable and brought them into a one thread, which were later were called scheduled caste, because all the subcaste were included in the schedule. That is why they are called scheduled caste. What is the solution of Dr. Ambedkar? The solution of Dr. Ambedkar is that he proposed a dual policy. I am not spending more time on this. One, he proposed the reservation policy, or a safeguard against discriminatory behavior to all the subcaste untouchable. Three set of policy or two set of policies. One, that there should be law against untouchability. Nobody should practice untouchability against any of the scheduled caste or subcaste. In 19 he argued, in 29 he argued, in a memorandum. Then he argued that since the scheduled caste face discrimination in public employment and other, they should be given a representation through a quota, subject to the minimum efficiency. This is the policy that he has given, which is accepted now. And this was also included in the constitution. Now, the follow-up action for this provision is the Anti-Untouchability Act in 1955, when Dr. Ambedkar himself was alive. Then Atrocity Act. This is a legal safeguard to the scheduled caste in public employment, in education institution, now in public housing. Okay? So that at least they get the share as a safeguard against discrimination. But Dr. Ambedkar didn't stop here. Dr. Ambedkar went a step ahead and he said that untouchable will deny right to property, right to land, right to business, right to employment in the occupation of high caste. The occupation of the Brahmin is to be a priest. Untouchable cannot become a priest. Occupation of the Shudra is agriculture. Untouchable were not allowed to own the land. Occupation of Vaishya is business. Untouchable were not allowed to undertake a business. Occupation of Kshatriya is military. Untouchable were not allowed to enter into military. Till 1942, when Dr. Ambedkar formed the Mahar Battalion. So you can see that the untouchable were denied right to employment and right to property, right to education. Right to education was denied up to 1854. It is only in 1854 that the British passed a regulation that yes, we allow education for poor and depressed classes. So right from Manusmriti was supposed to have been framed in BC 200. From BC 200 to 1854, untouchable did not have right to education, untouchable did not have right to ownership of land, untouchable did not have right to ownership of business. You know, in Kerala, Sanal Mohan Books has said that in Kerala the untouchable, they are not allowed to sell. What they will do, they will put their goods on the road and then sit about half a kilometer. They cannot be there. So somebody who comes, he buy, put whatever price he wants. That was the status of business. Therefore, Dr. Ambedkar, besides reservation in legislature, public employment and education institution, also recommended the policy of economic and education empowerment. And economic empowerment policy was distribution of land. Education empowerment was giving the scholarship and free ship and hostel for the scheduled caste, and also promote the business among them. Now this was not a reservation policy, this was the empowerment policy. Now what is the purpose of empowerment policy? Is the empowerment policy is for the scheduled caste as a group, or it is for the individual within the group? It is for the scheduled caste, but it is only for those group, those individual within the group which lack land today, which are landless. The scholarship is given only to those who are poor and illiterate. So, the distinction between reservation policy and policy of economic and education empowerment is this, understand. If you read his final document, state and minority, his constitution, there are dual remedies. One is policies against social discrimination, reservation, and policies against economic exploitation, that is nationalization of land, basic and key industry with the government, insurance and education with the government. So you can see very clear separation between the policy for individual, which cover all individual among all the scheduled caste. But the policy against discrimination and reservation only concern the scheduled caste as a whole, not as a subcaste. Now let us come to the point. With this background, let us come to the point. There is no data that there are subcastes within the scheduled caste that they lag behind. It is on the basis of the general experience that Pariyar are represented more, other castes are not. Mahara represented more compared to the Matan. Malas are represented more compared to Madigas, or Valmikis are represented more compared to Jamar. Because you can see that, but there is no data because there is no cost census. So the policy which some of the state government have adopted, Punjab, Haryana, Andhra Pradesh and others, it is based on the very rudimentary data. But still, even if we assume that some of the subcaste have a lesser representation in the government job compared to other, then the issue is how to increase the representation of those subcaste who are lagging behind. Do we give reservation to them? What? Or we give the policy which is recommended by Dr. Ambedkar. Now let me clarify this, and I will close this section. I think in Ambedkar's view, and also to a certain extent in my view also, that assuming that some subcaste have a less representation in government job, what are the reasons? Reservation policy is for all the individual from all subcaste in public employment. Scholarship and hostels and everything is for all the individual from all subcaste. And even other policies which are given to the scheduled caste are equally applicable to all the subcastes. And yet, some subcaste lag behind the other subcaste within the scheduled caste in representation. What is the reason? I think the reason in my view is the following, which I said earlier, that representation depends on education, education depends on economic standing of the father and the government policy. Now if this is the case, and if some subcaste have a low representation in government services in Kerala, for example, it is because some of the individual from that caste or more individual from that caste lack ownership of capital asset, ownership of income earning assets, and therefore those parents cannot educate their children as much as they should educate, and as a result their representation is less. Therefore Dr. Ambedkar had suggested that increase the economic capability and educational capability of the individual within the subcaste, so that their capability to take the government job will increase. Now my understanding is that if some subcastes are lagging behind in representation in the government job, it is because the sources of income in terms of land, business and good employment, they are lacking. maybe a higher portion is lacking compared to the other subcaste. Now, if you give reservation, subcaste reservation to some subcaste, what will happen? The economically better off families from this subcaste who afford education and then became eligible for the government job will benefit. The rest of them will not. So the inequality between the subcaste will remain. So Ambedkar's solution is, and my solution is, that the government should have a massive program for those individuals within the subcaste which is lacking behind, to give them the land, to give them the business, to cast a hostel, to give them the fellowship, to give them the scholarship and improve educational level, so that they can become capable to get the government job, because that reservation is applicable to everybody. It's not for one subcaste or another subcaste. I think that is the solution, that we will have to have a dual policy which Dr. Ambedkar suggested, reservation for all, because all suffer from untouchability. But those individuals within all subcaste, but particularly among the subcaste which are lacking behind, there should be a policy of economic empowerment and education empowerment, so that their capability to get the job is improved. Otherwise, what will happen? Within the subcaste, inequality will not promote between subcaste equality. This is my suggestion, this is Dr. Ambedkar's suggestion. But I may go one step ahead, because you have mentioned in your document that yes, if you like, that instead of subclassification and the reservation within the subcaste, it is recommended that these people, first step, as I have suggested, should be taken. Some preference can be given to them in employment. If their share in the government employment is less than that of other castes, government can develop some policy, not the reservation policy, but some policy whereby they get some preference. And the political divide of the scheduled caste can be stopped. At the moment, the intention is a division, a political division. So I think you should think on this line as far as the sub-classification and sub-reservation is concerned. But for that you require a survey. I have brought a copy before he wanted me to speak. I brought a copy of the caste census of Bihar. There are 22 subcastes in Bihar. And there is some variation, but I don't see any correlation. So therefore you will have to have a study of all the subcaste and the individual, and take an exercise that why some subcaste and individual among those subcastes are lagging behind, and then take the policy for their education and economic empowerment, and also develop some policies, some measure to give them preference in the government job, so that they come on par with Pariyar or the similar caste. But without data, it will backfire. The way Chief Justice of India has done, it's backfire. The last point I will say, the most weakest point in Chief Justice decision is the following. They were asked to say that if you recommend reservation based on caste, that is subcaste, how long we should go. They got, I don't think they had a clarity. What the Chief Justice said that, to give the reservation to each caste is a difficult task. 22 castes in Bihar, and there may be many more castes in other states. I don't know how many subcastes are there in Kerala. To give each of these subcastes is very difficult. He said, the reason that he gave, that some of the subcastes are indistinguishable from each other caste in terms of discrimination. So you should group them. How do you group them? How do you group the scheduled caste on the basis of discrimination? The restriction on marriage is in all the subcastes, isn't it? The intersocial relations are also less. For the subcaste, you use the caste as basis. That one subcaste should be given reservation. But when it comes to the individual caste, he said no. Can you see the contradiction between his argument? If you like, I would like to read that for you. It's very interesting. Not to take castes as a base and extend reservation to all subcastes. Look at that. On the one hand, he is suggesting reservation for subcaste, but going to each individual caste, he is saying, though some categorization based on each caste is permissible, we are of the opinion that there can never be a situation where seats are allocated for every caste separately. And then he goes on to add, though each caste is a separate unit, the social backwardness suffered by each of them is not substantially indistinguishable. You cannot define. Who will define? To warrant the state to reserve seat for each caste. If the social background of two or more classes is incomparable, they must be grouped together for a purpose of reservation. Can you see the inconsistency? Now, I think here I stop as far as the sub-classification is concerned. Let me come to the other argument very quickly. The other judges has talked about creamy layer, one generation, once, time limit, efficiency, and replacement of the economic criteria by the caste criteria. Let me give some explanation, then I will stop. It has been argued in this judgment that some of the scheduled caste, within the scheduled caste, now scheduled caste being mobile, a particular economic class has emerged, which can be called a creamy layer, the way it is done for the OBC. And then the judges go ahead and argue that this creamy layer, economically better off section among the scheduled caste, can develop on their own without discrimination. They don't require any support of reservation. The word used in the judgment is economically better off scheduled caste. Economically better off scheduled caste can progress on their own. They don't require support of reservation. What is the underlying meaning of it is? The underlying meaning of this is that economically better off section do not suffer discrimination, and they have developed a capability and strength to walk shoulder to shoulders with other, or they can develop on their own, so better exclude them. This is the argument. Same is the argument of economic criteria. That economic criteria is more important than the caste criteria. Marxist argument. Therefore, we should have an economic criteria. Then Pankaj Mittal, one of the judges, he go ahead and I would like to read out his statement, very important statement. Pankaj Mittal went a step ahead and provided evidence with observation that the experience showed that the better off class among the backward, that is scheduled caste, eat up most of the vacancies and seat reserved, leaving the most backward with nothing in their hand. So therefore, those who are eating away, exclude them and give it to them who are lagging. Now, how far it is true based on the facts? These are observations by judges without any evidence. How far it is true? Now, I have examined this issue. I had sent the article to Ambushekhar, which I published in 2016 in Economy and Political Weekly. There I dealt this issue. We have to deal two issues. First, is the reservation cornered by the economically better off and poor are completely excluded? Number one. Number two, how far it is justified to say that economically better off section among the scheduled castes can develop on their own and they became free from discrimination? These are the two issues that I will discuss with you. The first issue is that reservation has been cornered by a very small section of the scheduled caste community is based on a false fact and it is not correct. I have taken a position that reservation has mainly benefit the poor, economically weaker section of the scheduled caste, completely against the argument given by Pankaj Mittal. Reservation has been pro-poor among the scheduled castes. Now let me give you the statistic. In 2022, 89% of SC employee in the central government, 89% of the SC employee in the central government, 75 ministry, were in C and D categories and 11% in A and B. Who are the C and D among the scheduled castes? These are 4th class employee and 3rd class employee. I have checked up their educational background because they are poor, they are economically weak. So most of them are either higher secondary or secondary. Some of them are graduate. It is quite clear that the economically poor and less literate are benefiting from reservation by getting an entry into class 4 and class 3 posts, which account almost 89%. Only 11% goes to A, B and C, A, B and B. More direct evidence comes, again I show you, from the National Sample Survey on Employment 2022 and 23. About 78% of the government employees, central and the state, were from lower income household and the rest 22% from the top income. In urban area, same situation was there. So either you take a national employment data or you take the central government data. More than 80% of the posts are C and D, which are occupied by those with less education, higher secondary or some bachelor, and they are from the economically weaker background. Only 11 or 22% occupied. So you can see that one is shocked. The Supreme Court is the highest body and it is making statement without facts because it will result into policy. I won't say that they are prejudiced. Pankaj Mittal is prejudiced. Pankaj Mittal has drawn from the academic writing of some academician who says that the criminal is using the reservation policy. But they should have checked it up with the data before they make such a strong statement in the verdict. This is the first issue. So the argument made that the reservation is enjoyed by the economically better off and the poor are shut down is a wrong argument. Reservation policy has been pro-poor. Bulk of the economically weaker section from the scheduled castes have benefited from reservation and poverty is reduced, and the emergence of the lower middle class among the scheduled castes is because of this. Even I found, then I have taken the A and B, class 2, class first. In rural area, we get the land background of these government employees in category 1 and category 2 or aggregate. What do we find? All those scheduled castes who are in the government service, a very high proportion of them own land less than 2.5 acres or 1.5 acres. They got graduate because of the Government of India scholarship, hostels, and became eligible for government service. So even some of those who are in A and B, they are also from economically poor background, enabled by the scholarship, by the government and the reservation. So the argument made by the judge is very, very unfounded. Now let me come to the economic rating. Should we have a creamy layer among the scheduled castes? My argument is no. Why? What is the basis of reservation? That Dr. Ambedkar argued in 1919, 1930 and in the constitution, and finally we have reservation. Reservation is given to the untouchable. An untouchable is defined as a class which suffered discrimination in civic, religious, social and economic sphere, employment, property and education. Reservation policy in any country in the world or similar policy in any country in the world only given to a group which faced discrimination. It is not given to the general poor. For general poor there is an anti-poverty program. We had an anti-poverty program for last 75 years. But reservation policy is only for those groups which suffered discrimination, and because of discrimination in say employment, they landed up in casual labor and slavery like the slave in Kerala. Because of restriction in education, they are illiterate. Because of restriction in ownership of land, they are landless. Because of ownership restriction of the business, they are without business. But this is all based on caste. So discriminated group is a group concept who all suffered from discrimination. And therefore, a law against discrimination and reservation policy. Now the question that we have to ask is this. Do the economically better off section among the scheduled caste who got jobs and who have become economically better off, they have become free from discrimination. If they have become free from discrimination, no justification for reservation. They can walk on their own. But if they suffer from discrimination, you are obliged to give them protection through law and see that he or she is not discrimination in getting government employment or government assignment or government business and others. That is the key thing. If the discrimination is the base of the reservation, if the economically better off section among the scheduled caste face reservation, face discrimination, they need some sort of a safeguard. You call it a reservation or you call it something else. Now what is the evidence? I spent entire life on studying the economic discrimination of the scheduled caste. You take atrocities in Kerala or outside. Do the high caste see the economic background of the scheduled caste while stopping them not to have access to the temple, or not to have access to the well, or not to have access to the public way? Do they take economic background? No. They take social background, whether it is untouchable or not. Whether he own a 10-acre land or he own a 2-acre land, they are not allowed. If women are not allowed in Sabrimala, they were not allowed earlier. The priest doesn't ask the economic background of the woman. He only see that she is a woman, and woman is not allowed. Group identity, group discrimination. So if you look at the atrocity data today in India, about 4 lakh cases for last 2002 to 2014-15, 4 lakh cases I think, 14,000 cases per year. They also include the economically better off section among the scheduled caste, because this discrimination is neutral to your economic standing. Discrimination is based on your identity, whether you are untouchable or not. We have given reservation to the woman, 30%. Have we said that economically better off woman will be excluded from the reservation in legislature? No. Why? Because women economically better off or worse off face gender discrimination. You know, I was coming by a plane yesterday from Hyderabad to Kochi, and I saw about 10-15 youth with a black cloth and holding something on their head and entering into the temple, entering into the plane. I was very surprised. These are all young. Where are they going? So fortunately, where I was sitting, one young man was there, and I asked him, "What are you holding on your head?" He says, "Sir, it is ghee. This is being given to the Sabarimala. I think it is given to the Brahmin priest or it is given to the god, and the Brahmin priest will carry." And I said, why this black cloth? He said, that is the tradition. But I said, I don't see a single woman along with you. You have sister, you have mother, you have wives. And he kept quiet. So discrimination is group-based, irrespective of economic standing. The mistake that Marxists commit in the 70s, now the Marxists agreed the caste. In the 70s, they commit the mistake that only problem is class, economics, not caste. But now they have begun to agree. They haven't examined the class base of the caste as such. So therefore, what I am arguing is the following: that since economically better off scheduled caste also face discrimination, and I stop in between, all my studies shows, recent book I have brought out, scheduled caste and labour market, employment discrimination of the scheduled caste and impact on poverty. What I found there, I won't quote the other study, but there I found that even the scheduled castes who are occupying the higher position in the private sector, there is a discrimination. Lower level there is less discrimination. Okay, you can be third class, fourth class employee, but upper there is discrimination. So your income level is high and still you are discriminated. There is a discrimination in land market. The high caste refuse to, reluctant to sell the land to the low caste. The high caste are reluctant to buy the consumer good from the grocery shop of the scheduled caste. High caste avoid to buy the noodles from a businessman of scheduled caste. This is what we have. Now, if the economically better of scheduled caste face discrimination and you say that you excluded from reservation, what is the protection that they have against discrimination? Their proportion will fall down. So my suggestion would be that the reservation for the economically better off should continue. However, there is one rider. This can be examined, this can be further elaborated, that the economically better off section among the scheduled caste do not require financial assistance for the education of their children. They can afford to pay the fees. So all subsidies that are given to the scheduled caste, economic subsidy, priority for business, priority for land distribution, scholarship, fellowship, that you don't give it to the economically better off scheduled caste. But you cannot say that they cannot be given reservation, because this has to be given because they suffer discrimination. So if some of them are voluntarily want to withdraw from reservation, that's fine. So this is my solution, that the economic advantage that scheduled castes have, withdraw that advantage. Don't give subsidies, don't give concession, but don't stop reservation. This is an argument. This is my argument both for creamy layer and economic rating. Let me come to the last point. Is the very serious argument made by the judges that reservation be given only once and one generation. What is the ground? No justification. If there is a scheduled caste family whose son has become a class 3 and class 4, 80% of their are class 3, class 4. By using the reservation once or one generation, have their problem disappeared of discrimination and economic deprivation? I think to make this kind of an argument without any foundation, any evidence, is a very poor argument. All those suicides that are committed in IITs and universities by the student, quite a few of them come from economically better off background. They are second generation. Solanki, who commits suicide in Mumbai IIT, was a second generation. His father was a government officer. Still he faced continuous discrimination in IIT. Quota student, another thing. The judges should provide an evidence that by using reservation once or one generation, the discrimination will disappear and there won't be any need for reservation. But making this kind of a loose statement, I am surprised and I am shocked. The last point is that it should be time bound. How long reservation can be continued? I think this is the important point and correct point, that reservation cannot be continued for all time. It has to be stopped somewhere. There is a country called Japan where there was a reservation they call special measure for Burakuman, and in they withdrew the special measure. But what is the criteria that you should use to remove to set the time limit? They don't discuss the criteria. There are two criteria. One, that the scheduled castes do not face discrimination, minimum discrimination. And that gap between the scheduled caste and the higher caste has been breached. They have been brought on par with others. These are the only two criteria for discontinuing the reservation. Is that the reality? Malnutrition, in housing, bulk of them stay in the slum, is there. And you go ahead without any verification, without any giving any criteria, you say that there should be time bound. So I do not know what is the attitude of the judges. I think reservation can be curtailed, provided that the scheduled caste do not face discrimination and that the gap between high caste and the low caste is reduced. The last point, that you develop other criteria other than the caste. Pankaj Mittal, Justice Pankaj Mittal. I'll finish in 10 minutes. Pankaj Mittal says that Constitution provides law of equality in the Constitution. No discrimination based on any. And yet the reservation is given on basis of the caste. It is promote casteism. Casteism. How far it is true? This question was dealt by Dr. Ambedkar. If you read his book, What Congress and Gandhi Were Untouchable, that reservation will lead to the perpetuation of the casteism and caste system. Dr. Ambedkar argued that no. By reservation, the equality will emerge between high caste and the low caste. They will participate together, they share their experiences, and casteism will reduce. Harmony will emerge. He has said that if the scheduled caste legislature sit in the state assembly, high caste and low caste MLAs talk to each other. Understanding improves. High caste began to understand the problem of scheduled caste. A student from scheduled caste enter into the higher education institute through reservation, they interact with the student. Harmony build up, understanding build up. Same is the employment. When a scheduled caste employee and high caste employee work in the same office, the high caste employee began to understand their problem and develop sympathy. So the reservation being harmony, unity and not division. But this gentleman is saying it being casteism. And the last point that I would like to end with is that most shocking thing in this judgment is that Pankaj Mittal has a 1.5 page para in which he said that I support Varna system but I oppose caste system. And then he said that and Varna system of Gita. And then he said that I read Gita regularly, I read Ramcharitmanas regularly. There was no reason for him to add a separate para justifying Varna system and rejecting caste system and saying that Gita is good, Ramcharitmanas is good. Everybody knows Ramcharitmanas by Tulsidas has condemned Shudra and woman and favor Brahmin. I don't think he has read it properly. If he is giving a creditability to Ramcharitmanas, which means he is giving creditability to the lower status of Shudra as well as lower status of woman and privilege to the Brahmin. But more critical thing is Gita. Gita's Karma Siddhanta, Varna system. What is Gita's Varna system? He says that the Gita's Varna system is based on qualities. Better qualities, Brahman, Kshatriyas, Vaishya. Poor qualities, Shudra and untouchable. Based on qualities. It looks very sound. But what does Gita say? Gita says that the qualities of the individual are innate, original, They cannot be changed. Therefore, they can be classified into Varna. And where has he taken from? He has taken it from Manusmriti. I will read out the paragraph of Manusmriti. A Shudra, though emancipated by his master, is not released from servitude, since that is the innate in him who can set him free from it. Can you imagine? The Varna system of Gita is drawn from Manusmriti, and Pankaj Mittal is justified. Dr. Ambedkar says in a nation of caste that it is the Varna system of Arya Samajis which has given the birth to the caste system.